considered is what is it offered for? So in other words, if someone came in and said, to decide whether the ordinance is valid, you need to at least hear what the people who made the decision heard, whether it was true or not, right? Then would it be, if it were relevant to simply say, I'm giving you this because you need to see the totality of what the council heard when it passed that ordinance, does that mean, do you think it's excluded in that instance? Even if you're saying, I don't care whether it was true or not because it wasn't under oath, but you as a zoning board need to hear what went on.
So that
is that relevant?
I don't want to jump.
No. Do you,
Yeah.
and I'll let
No, I don't think it is at all. What you'd be doing in that case is second guessing city council. You would be exploring why they made the decision that they made. And city council is under no obligation to explain to the zoning hearing board why they made the decision they made. They made the decision. Now you have the decision. The decision's out there, and it's up to the applicants to demonstrate that that ordinance violates due process, substantive due process, whatever it is. That's their challenge. What we're being asked to do, I believe, is to engage in a critique of city council's actions. Should they have done it? Should they have not done it for these reasons, those reasons, or whatever? I don't think that that's what this should be about. This should be about the actual ordinance, the ordinance itself. Is it directed at a single property? If it is that property indistinguishable from properties that surround it? Does it have no distinguishing characteristics? The rules are out there for evaluating ordinances. The set of rules that are being suggested now, I got to tell you, it's bizarre. I've never seen this before. I have never seen a request, never, and I've never read a case where the courts went back in, opened up the legislative record, and critiqued what the legislative body did. I've never seen that. They stay away from that. In fact, the presumption is, and the attorneys know this, the presumption is that that legislation is valid. That's the presumption. It goes in with that presumption. It's up to the objectors to show that it is not, and the rules for showing that it is not do not include an examination of what the legislators were thinking. It includes an examination of what are the effects of the legislation. Is it directed at a single property? Is it discriminatory? Is it spot zoning? Is it what? It's not what they were thinking, not whether the chairman of council was a good guy or not. That's not what this is about.
Yeah, because I still come back to it. I think the issue is that truly correct? That there can be no consideration of, for example, what the council heard, or a council member's, if there was a record and a council member said on the record, I want to do this because I love the color blue. And everyone looks and says, well, what does that, your position would be, doesn't matter, right? Doesn't matter why a council person said they were passing this. You're saying that's irrelevant, which is why you don't admit this. Am I understanding that? Because I think he's arguing that the reason they did this doesn't, I mean, that's the argument. There may be case law to support that, but I just want to, I need the answer on that.
There's case law to support it. And
okay.
I don't want to speak out of turn, but I should recite the law that applies. Apparently, Mr. Preston has not read the appellate decisions that apply to this process.
Okay.
The process of a zoning hearing board and the higher appellate bodies reviewing an amendment to
then I think that's what we need to do. We need your position on that, because I think we've reached the point where I understand their position, but if you are correct, then we have to consider the case law to support the idea that it becomes relevant.
Mr. Shire.
Yeah. Hold on a second.
Case
okay.
that I was referring to, I don't know if you want me to continue.
Well, let him say what he needs to say, and then we'll come back to my question to you, which is, give me the case law that says we have to consider it.
I think that essentially what the board, as I understand the thinking from Ms. Shakeharter and Mr. Jacques, I understand the idea of that if Mr. Stevens is offering the transcripts to, in effect, demonstrate an effect on the listener being city council, And I think to do that, then you would have to almost consider what, if any, statements City Council made in their deliberations in response to those, in response to the comments made by the members of the public. I think it's difficult to do that unless, for example, council members are specifically referencing a certain comment that a certain member of the public made. I don't know how else you would kind of divine what council members were thinking when they made their decision. In addition, it's my final point, I still think if, at some point though, what is said is relevant. Now maybe, or what is said has to be taken for the truth. If it's not the speakers, and if it's only how council members were affected by the speaker, then at the very least it is the council members' statements that must be taken by this board for their truth. In other words, if some council member said, well, Herm Ridge, wrote a $10,000 check to my campaign, and that's why I'm voting for this amendment. I know it didn't happen. I'm just saying that's why I'm voting for this amendment. That would still have to be taken have to be taken for its truth. And what I would argue is a statement like that would have to be offered under oath for this board to consider it for the truth. I don't think at some point you have to say, well, none of these statements were made under oath. When this board considers the matter, we have to take statements that are offered for their truth to be under oath. And if none of the statements were made at City Council or at the Planning Commission under oath, this board cannot receive them and cannot consider them.
So give us the case law, if you could, that you think makes this evidence relevant. I think that's the...
one of a number of examples.
Sure.
And there's a whole line of spot zoning cases where the reviewing body, the zoning hearing board, and then it goes up, common pleas up to the Commonwealth Court and maybe beyond. They're exploring what the thought process was and considerations of the underlying record and what the board members were deciding and the basis for their decisions. That's exactly what this zoning hearing board is charged to do. And the case is the Baker versus Chartier Township Zoning Hearing Board, 677 A. 2nd, 1274. I picked that case because it aligns with our situation in that it was a challenge to a zoning amendment and it was deemed illegal spot zoning. In that case, there was a parcel adjacent to a landfill and it was deemed illegal. Key to that case was the zoning hearing board, in its determination, failed to evaluate the impact of the zoning amendment and failed to properly assess whether or not it comported with the planning, the comprehensive plan of that township. Those are key issues that are in this record that I'm asking this board to review, because both of those things were not done. And I'll even read to you to demonstrate to this board that you are to delve into what the thought process is of the city council and what their bases were in making their determination. And yeah, there's a lot of irrelevant information in these transcripts. That's our position. That's why the zoning amendment is invalid, because there were irrelevant considerations. Yes, he's going to pay $100,000 in taxes, or he's going to donate to the mounted police. There were all these irrelevant considerations in their final determination. But let me just read.
Before you get there, just, sorry, pardon my interruption, but was that one particular property, or was the ordinance related to a number of properties that would have been spot zoned?
In this case, this is a parcel adjacent to a landfill from agricultural to industrial is illegal.
So it was on one property?
I would have to delve further into the facts to see exactly.
I think that sounds like it was a map amendment.
Correct.
But, so the facts will be different, but read us the section you were going to read to see if it's general enough on the principle we're asking you the question on, which I think that's the essence of the dispute between both sides here is this one. Do we need to hear these things, or as Mr. Preston and Mr. Deschler suggest, for a variety of reasons, we shouldn't be hearing them, right? So.
That's why and this court certainly heard them. And the court's saying, this is the comment where we agree with the trial court that procedural irregularities indicate that the board failed to make full and fair examination of the impact of rezoning in its attempt to accommodate Martin being an applicant. Because of the sanitary landfill's prior potential ability to generate funds from the host agreement, and because the host fees allow the Board of Supervisors to keep down taxes in the township, the environmental impact of the debris zoning and its conformity with the comprehensive plan was not sufficiently explored by the board. They're looking at what the board did, what the board in this case failed to do. That is all in these transcripts, because one of our, number of key arguments, but one of our main challenges is that City Council failed to adequately do their due diligence and conduct sufficient research to determine what the true impact of the zoning amendment is. Another key argument, which is here in the Baker case, is the City Council failed to do its due diligence to make a determination as to whether or not this zoning amendment comported with the comprehensive plan. The only way you're going to learn that and be able to review that is if you review the transcript and have that evidence of what City Council heard by way of testimony, what they reviewed by way of exhibits, so you can make that determination if, in fact, City Council dropped the ball and should have done more by way of due diligence, should have done more to see if this zoning amendment comported with the comprehensive plan.
So is it your position that we are allowed to second guess what City Council did then?
You're there to review what City Council did to make a determination if they adequately explored the basis of this zoning amendment, to make a determination if it impacted just one property, if it impacted 3, if it impacted 64. It's our position that wasn't done. And you're here to review this record to make a determination if, maybe it was adequate, but maybe it wasn't, and you agree with the appellants that more should have been done, and this amendment should be stricken. And that's one of a number of issues, but there are plenty of others where you need to review exactly what was before the City Council in these transcripts to make that determination.
I guess I didn't hear that in what you recited about the Baker case. So what are you saying in that Baker case specifically says that we should delve into those transcripts which are not under oath, etc.?
Because they would, in order to make that determination, the reviewing court here had to know what the board did. How could they find that out without having the underlying records of what the board did or didn't do?
By having witnesses testify at a zoning hearing.
And that's our position on that is, okay, we're going to replay every single aspect, every single witness, and recreate what's already basically been done. I don't think that's the function of the zoning hearing board. The zoning hearing board, in this instance, is a reviewing body and is there to review, to make a determination as to whether or not this zoning amendment is appropriate, what council did in its passage was appropriate. I mean, they're specifically saying that it was an improper decision on the board's part to accommodate Martin, the applicant. So they're looking at what the board did in this circumstance. How else can you learn that without reviewing the underlying?
Well, I guess I have a question. I mean, could theoretically someone come in and say, I'm challenging the ordinance, set up a tape player, and then just play the recordings for 9 hours straight to a zoning hearing board? Right, because you can use an audio recording as evidence, I think, correct? I'm not asking someone to do this. I'm just saying, in essence, this is, please, no. But I'm just wondering, I mean, that's what he's saying is, right, wouldn't the best evidence of this theoretically be if someone came in and played the tape, if it's relevant? That's what I'm asking.
I would agree with that. If it's relevant, and obviously they have someone here who purports to be able to authenticate the transcripts, I have no reason to doubt that.
Right.
Right, so if I think maybe we're skipping a step in that I do believe Mr. Stevens wants to introduce some of the statements in these transcripts for their truth. But if,
I've got you. I'm saying, I don't know that I'm worried that much about the transcript, because theoretically, someone could come in and have the right to play say, I'm going to play these tapes, sit here, folks, and play them, right? So it's really not the transcript itself. It still becomes, should we be hearing that whole discourse, either through reading it or hearing it live? Which goes to your issue of, there's other issues why it shouldn't be in, right?
right, and I still think that with the transcripts themselves, if you're considering the statements made by, for example, council members, I still think you would have to consider those for their truth. And therefore, I think that those statements would have to be under oath, and obviously they weren't.
Right. And that wouldn't matter if someone came in and played it. If we sat here and listened to it, it'd be the same objection, theoretically.
Correct, because the recording still wouldn't be under oath, the council member statements would not
I
be
get
under
that.
oath.
No right to cross-examine the whole.
Right.
Correct.
So we still come back to, while there may be things that impair this evidence from on that, so you've really got an argument that the evidence is imperfect to begin with, and then we have a separate argument of, is it relevant? Should the board be learning, or listening, or reading, or hearing the entire, the entire board hearings, right? Okay.
I respectfully may respond, but as far as the ability to cross-examine, they have every opportunity to do that. I've shared with them the transcripts. The witnesses are all there. They attended the hearings. If they want to call any of these witnesses and cross-examine them, now they're in better shape. They have the chance, they can cross-examine them even more, because now they have transcripts that they can cross-examine them and get more information. If the concern here is fairness and the ability to cross-examine and making sure the truth comes out, they have that ability. They can subpoena anyone. Of course, the chairman would have to issue the subpoena, but subpoena any one of these witnesses, cross-examine them until their heart's content to make sure the truth does emerge. What I'm saying is that I think you're really hiding the truth, because you're excluding from your consideration that legislative history, everything that transpired with respect to the considerations, all the evidence and the testimony that City Council considered, and absolutely, what City Council considered and the bases for their determination is up on review, and it's replete in the spot zoning cases and other cases dealing with rezoning.
Do you have a case, I understand the point you're making using that Chartiers case. Do you have a case, though, that I think answers Chairman, Board Member Gardner's question, which is one that just says, you should be listening to that transcript or listening to that hearing? I think, is there one that says that? I'm not saying that means the decision's being made. I'm just curious if any of those cases say, somebody did what I suggested, which is they came in and played a tape of exactly what the audience and the council said at that meeting. Is there a case that says that you're aware of?
I don't know if there's a case that is that specific.
Specific? Okay, fair enough. I mean, you can't write it.